Welcome to the PI show. My name's Harry Nowicki and we're here to talk about personal injuries, joined by Tony Carbone.
Good evening, viewers.
And backed by popular demand is Jennifer Cron. And all of us are
Tony, Harry.
PI lawyers who are interested in injuries and all the consequences of injuries. And by popular demand, last week we were talking about medical negligence and we covered some topics, but the field of medical negligence is very wide. People sue hospitals, they sue doctors, they can sue other health professionals,
That's right.
apart from doctors and
Physios.
chiropractors. So people who have treatment and things go wrong often consult a lawyer and can sue. So the medical negligence field, to me, has expanded over the years. And the other thing is that there was sort of a crisis with insurance for doctors. And I think that crisis has been reduced over the last few years. But tonight we're just talking about one area of law, which is that people who have been misdiagnosed and
or have received inadequate treatment. They could have received alternative treatment,
which wasn't
perhaps available. Or well, not that it was available, but that it wasn't offered to the patient.
So, in those circumstances, they maybe come to a lawyer and get advice about that. But how does a lawyer run the case like that? I mean, it's all fairly speculative, isn't it? Someone's misdiagnosed. What effect does that have?
Well, Harry, I mean, basically you could have the loss of a chance of a better outcome.
Okay, so...
And there's been quite a number of cases that have been decided on that basis. A few of the plaintiffs have actually been successful.
And one case that's been decided in Victoria, I think in, this was
2001.
Mr Gavalas. What were the facts in this one? I think he was 30...
He was a 30-year-old gentleman who was being treated by his GP, Dr Singh. He had been suffering from headaches and had been continually going back to his GP. Some 10 weeks later, he went back again and his GP then eventually sent him for a CT scan. The CT scan diagnosed that he was suffering from a tumour, brain tumour, which was of a significant size. Okay,
so he then, I presume, consulted a lawyer and then the lawyer decided to sue Dr Singh.
Correct. But not only that, he had to undergo surgery. Now, when he underwent surgery, the tumour was of such a size that not all of the tumour could be removed.
So he's left with some...
He was left with some of the tumour and this subsequently grew back and he had to have further surgery. And as a result of that, he suffered cognitive problems, epilepsy and other neurological disorders. Yes, that's right. So he was left with disabilities that he may not have had if the CT scan had been done at an earlier stage.
Basically, the tumour was of a size that it was very hard to operate without interfering with some other part of the brain.
Well, there's a lot of structures in the brain that you have to be very careful. I mean, it's such delicate surgery.
Dare I say it is brain surgery?
That's correct.
It is brain surgery.
It was pretty big.
It was about 5 centimetres, which is
extremely. That's large.
All right, and then so he sued Dr Singh, and what happened in court?
Well, in court he was successful.
Okay.
They awarded him $30,000 in damages, which really actually isn't a very modest amount.
It is a modest amount.
So.
And what did the defendants say in their defence?
They did not believe Dr Singh had been negligent in failing to order a CT scan at an earlier stage. So that you need to marry up causation, obviously, in any medical negligence case. That is, it's sentinel that must be shown.
Okay.
So they argued that there was no causation in this case.
So the failure to do a CT scan didn't lead to a brain tumour, if you like. He had a brain tumour regardless of whether it was detected or not.
Correct.
But, okay, and then the courts then say, or the court then said that he suffered a loss of chance. So I think in this case they did find that the doctor was negligent. He should have.
Yes, they did find that he should have. He was negligent in not ordering the CT scan.
There's no doubt that the tumour would have been smaller 10 weeks earlier.
Well, it's
and the
it's
chance
supposition.
of getting a better result would have been much higher. I mean, there's a logic in that. It stands to reason.
It would
it's common
be dependent.
sense,
Yeah.
but the courts always don't look at common sense.
Well, no, they said
not all judges.
No, they said the chances of a better outcome might have been greater.
Yeah,
might have been greater.
Yeah.
It's speculative.
But it's so speculative that is that why the damages were so low? It strikes me if someone's got
that the damages were quite low, particularly as he'd suffered further problems, having to undergo subsequent surgery because the initial tumour could not be totally removed.
I reckon they were too low. 30,000 for something like that is just...
Well, funny you should say that because Mr Gavalas appealed to the Court of Appeal, and
that's right.
What did the court say?
They remitted it back to the original trial judge to reassess the damages.
So they sort of agreed with Gavalas, but they couldn't make a decision about what it was worth in the end. So they said go back to the original judge, and they produced some reasons, and they said in effect that the primary judge should have another look at it and reassess damages.
Well, wouldn't the three judges make up their own mind about what it was?
Well, I guess being loss of chance, it's speculative on the percentage of
but
him being 100%.
There would have been enough material before the Court of Appeal.
You would have thought so.
I don't know if have they got the power to do it in those circumstances.
I know under the work
legislation
I think they do. They
can they substitute?
They could have. They could have.
Did they send it back to hear more evidence? I don't know. Is that what they did?
They sent it back, and they wanted the judge to read the reasons why they upheld the appeal, where loss of loss of chance was the main reason why they said send it back, and the judge probably didn't assess loss of chance. It seems, I think, it's settled out of court after that. So
yes, I would say so, because there wasn't any
further hearing or any further decisions in the courts.
Well,
that's correct.
I mean, what's critical in the Court of Appeal is that they say a portion of the blame for the eventual outcome was attributable to the doctor. The damages were reduced.
They apportioned it.
Yeah, they apportioned it.
That's what they did.
Well, we'll come back with another example of this sort of peculiar notion of loss of chance after the break. See you then.